And people should start coming through now. Hi everyone, welcome on board. We're just waiting for David, who will be joining us as one of our key panelists. But I guess while we're waiting, where are people joining from? Where in the world's everyone dialing in from? Very current, given the topic of the webinar. I'm in London, by the way, where it is a beautiful day outside. Got some sunny Bristol, sunny Leytonstone. There we go. Got a lot of sun going on. It seems to be the way. Marguerite, where are you?
I'm also in London, sunny London.
Aha. I do not know where David is. I'm sure he'll show up. Anyone further out than Bristol? We've got a Hertfordshire here. No one overseas. I feel like we must have some Americans, South Africans, Europeans. Maybe not. Okay, well, while we're waiting for David, who I'm sure will be along shortly, thought I might just get us started by introducing the webinar today and introducing instant impact, and then if David doesn't come, I think we'll just pivot it into a bit of a Q&A session, and people can ask their burning questions around remote working. So, I mean, first of all, welcome. It's the first of these webinars that we've run for some time. We took a bit of a break over the summer, but it's really great to be back into it. And thanks to our panelists, Marguerite, and soon to join us, David, to join us. But for any of you who haven't been to an Instant Impact webinar before, we run a sort of Q&A session at the end, for the majority of it. So if you do have any questions that you've been wanting to ask all around sort of hybrid working, there's at the bottom of your Zoom somewhere, there's a Q&A box. Pop them on there. If it's a sort of current question that we can get onto, we will do our best to answer it as we go, or we'll come to it at the end and have a bit of a discussion at the end of the session. If the other thing we're going to do is we always send around a feedback form. It's so important if you could fill that in. Just give us a bit of feedback on the topic, on speakers, of course, and that really helps us to inform what we're going to tackle later, what content we're going to run later, but then also get better as a with our webinars and with the content that we're putting together for you guys. So that'd be really great. As many of you will know, I'm Felix. I'm one of the co-founders and co-CEOs at Instant Impact. And at Instant Impact, we specialize in in-house recruitment. So building, running, and improving in-house recruitment functions for our clients. And as you can imagine, because we sort of deliver the recruitment across an extended period of time, this sort of question of what's the future of work going to look like has been really front of mind for us and for a lot of our clients. And whether people have loved the working remotely over COVID or absolutely hated it, I think without doubt it's definitely changed the way that we've looked at talent and changed the way that we've looked at what a workplace looks like. So we've been helping our clients over this period. First of all, it was a bit of an adjustment period, but now that we're all used to the idea of working remotely or hybrid working, we're looking at what they can do to get the most out of that. So many of our clients are now looking at national talent pools, depending on where they're based. Many are looking at global talent for the first time, so questioning whether they need to even hire in the same country as the office is based in. All of them are excited by the ability to build more diverse companies and working remotely is really exciting for that. Tapping into single parents, people with disabilities that prevent them from commuting every day, people from sort of more isolated areas, which are often the most economically deprived. And that's really exciting. And I think the other really exciting thing is it's not a topic that people can shy away from. Everyone has to have an answer to what their remote working policy is going to be like, because it's become such a key factor in hiring and such a key factor in retention. And it really is one of the big employer brand drivers at the moment. And it's probably one of the, I would say it's in most cases, one of the first 3 questions that will get asked by candidates that we're speaking to is around what the company's approach to remote working has been and what it's going to be going forwards in the future. And I've got to say, it's really exciting as a business specializing in recruitment, but also a business that is recruiting quite actively ourselves. So we've grown since the beginning of the year, we've grown from a team of just under 20 to a team of just over 50. And to do that, anyone that's recently tried to hire in-house recruiters will know just how competitive that talent pool is. So even just to keep pace with our growth, we've had to explore a global talent pool. So we hire talent wherever it is, wherever the best recruiters are. So from that's been from here he is, the man himself. Don't worry, Dave, we're still in the intro section.
Felix, sorry I'm late. It's I've been struggling to get into the attendee side of the webinar.
No problem. I thought that's what it might be. Well, you're very welcome. I was just saying that we've been at Instant Impact. We've been hiring from Belfast all the way to Port Elizabeth in South Africa, all the way to Nebraska in the United States, just wherever the best talent is, and that's something that a lot of companies are looking to do, and it's really exciting. But I know that it comes with its challenges, and as the pandemic winds down, we're all sitting here and coming up, trying to figure out what the new status quo is, and everyone's coming up with very different conclusions. Some have gone remote first, like we have. Some have gone all back to the office, but most have got some degree of hybrid. And every single one of these solutions comes with its specific challenges, and that's what we're looking to get into in the webinar today. And very lucky to have Marguerite and David tackling the legal and tax challenges respectively. And I'm here to answer any questions around recruitment and talent. So the format of today is it's a bit of a presentation from David and Marguerite, and then we're going to go into a Q&A session at the end. So please do ask all of your questions, but sorry for the technical issues. David, it is now over to you. Oh, I can't hear you.
Thanks, Felix. Can you see my screen?
Got it. And we can hear you.
Excellent. There we are. Sorted finally. So hi, everyone. Just to quickly introduce myself, I'm David Udall. I'm a tax partner at Smith Williamson. I specifically help employees with employment tax issues and international employment tax issues. And as Felix said, the past since the start of the pandemic, there's been an incredible trend of allowing more employee flexibility, and particularly working from anywhere, whether that's in the UK, from their homes, or anywhere in the UK, or even internationally abroad. And so what I'd like to do, I'd like to just provide you with a bit of an overview of the impact of that today, commercially, in terms of tax, and what the pitfalls should be if you are considering formalising any sort of policy or allowing your employees to do this. And I think there's really, just to start off, there's kind of 2 sides to this. There's allowing your employees to undertake hybrid working, which is extremely popular. It's popular to the point where if you don't sort of become flexible in your domestic working arrangements, it can affect your retention of staff, and it will be regarded as important as pay when it comes to your management of your workforce. And I think there is a, I found this with a few clients, this is what I want to present to you on today, that there's a presumption that if you change somebody's working place from the office to home, that there's a ton of income tax relief that can arise as a result of it. And what HMRC introduced from March 2020 during the start of the pandemic was some relaxations in terms of things like buying equipment for home, and purchase of or claiming a home working allowance, or paying your employees some sort of additional £6 per week, which would be regarded as non-taxable from the arising from the fact that their circumstances are that they have been mandated to work and stay at home because of safety. And the rules there differ during the pandemic, and specifically for last tax year from 5th of April to 6th of April, but also for the current tax year, the 21-22 tax year, again regarded to be during the pandemic period. So the rules are, office equipment. A lot of employees have seized the opportunity quite naturally. Can you hear me, Felix?
Sorry, we lost you at the rules are.
Sorry, right. That's a helpful point to.
Yeah, I was going to say, way to build the suspense, David.
Yeah.
I love it.
Yeah, indeed. Yeah, I did it deliberately. No, I didn't. But essentially, there is a relaxation to buying equipment to use at home for office purposes, for home office purposes. But and if an employer pays for these on behalf of their employees and provides them with the equipment, it's not taxable for the pandemic period, and up to, at the moment, up to 5th of April 2022, to the end of the tax year. However, a lot of employees have asked us questions. So does that mean I can go out and, get a high spec office at home? Can I get a 60-inch plasma TV as a second screen? Can I buy a super duper chair that's a bit over the top, if you know what I mean, but basically take advantage of all these costs as non-taxable? What HMRC would say if they were in the room would be it's on a reasonable basis, so equivalent to what you would have as if you were in the office. And whilst there isn't a prescriptive set of examples, if there is anything that is above and beyond what's typically regarded as standard equipment, there could be an issue from a denial of the income tax relief if it's been found out. So I would say to those who are on the call today that if you do have a policy like that, for example, you give the employees a set amount each year that they can claim up to in buying chairs, monitors, a mouse, home office equipment, that you do have in your policy somewhere saying that it has to be on a reasonable basis only. Now, after this relaxation ends, and I'm saying after 6th of April at the moment, because that's where the concessions end right now, those will be regarded to be taxable benefits on behalf of the employees. So very important to recognise that any income tax reliefs that you want to take advantage in respect of home equipment should be done now, not waiting until a period when the concession is removed. Another element is where an employee's workplace is removed from being the office to home, but they are asked to come into the office every now and again just to connect with the teams, connect with clients, and undertake their role, but because it would be nice to see their face every now and again, whether that's once a week, once every 2 weeks, or once a month. Now, really, really important to understand that just because somebody's contract has moved to being at home, it doesn't mean that the office then becomes a temporary workplace that they can claim income tax relief on or expense their travel without having a tax impact. In fact, if you are stipulating for somebody to move to home working because of the hybrid policy, but are asking them to come in as a part of a regular pattern, because of the rules that HMRC set out regarding the home to office tax relief, it won't be eligible for any form of relief unless there is a totally objective reason for them to come into the office. So a non-objective reason would be to come in and meet or spend time with your colleagues, to come in for a regular team meeting. These are the reasons that we see most commonly, and what a pitfall is assuming that train ticket or the mileage can be expensed. A purely objective reason would be to meet a third party who's associated with the office. So, for example, a client or a third party provider of equipment, but But essentially, that's going to probably narrow it down by about 90% of cases that are going to have income tax relief denied. So really important to understand that if you are going to have a domestic working arrangement, don't assume that the tax breaks are going to be there past the pandemic period, but also don't assume that this is going to change the nature of the office as a workplace for employees. I'm also just going to move on to now something which I'm seeing a bit more frequently, which is the international working arrangements, which is where you've got a hybrid model of working in place, but there's different considerations really in respect of international work. And you can see hopefully on the screen that you've got various things to think about, such as income tax, social security, corporate and indirect taxes, and taxable benefits and expenses. Now, taking a step back here, the reason why during the pandemic, I think that there were a lot of cases where maybe overseas workers who were in the UK but have family overseas sort of spent time reflecting, why do I need to be here? If I'm being mandated to work at home, why on earth do I need to be in my flat in London when my family are based in France and I can go and work, I do my job effectively there? Why not? Well, when a UK organisation has employees who are operating cross-border, that has an impact in terms of employer and employee compliance. And the issues on the screen have a double-sided sword in respect of, for example, income tax. There could be an income tax presence established overseas, as well as potentially, if that's the case, an impact on the employer. Same with the other issues, and I'm just going to talk to you about them each in turn. So let's start with income tax. If an employee works overseas, a tax authority will typically say that tax is due if you are working in our country. The UK, however, does have a series of double taxation agreements with a lot of countries worldwide. You can find a list of them on the government website. And there is a model article regarding employment and temporary work overseas, usually around paragraph 14 or 15. And that follows the Organisation for Economic Development and Control model, but each treaty has a slight variance. But overarchingly, what they will say is something along the lines of, if we have an employee, or if you have an employee working in our country for no more than 183 days within a 12-month period, so long as their costs are not recharged to any entity that exists in our country within the group set of group companies, and so long as they aren't working for the benefit of a permanent establishment or a fixed place of business which the UK business has overseas, then there will be no income tax due. And whilst that feels generous, basically up to 6 months in a rolling 12-month period, it can get complicated when the pandemic period has lasted a lot longer than 6 months, and also where you've got individuals who might choose to spend 5 months overseas, but because they're going back to their country for, let's say, Christmas, for Easter, for ad hoc holidays throughout the year, that can easily trigger over 183 days. And so if that's the case, right, that does create a serious area of risk in regard to income tax. Because from the employee's perspective, income tax will be due in another country. And if they are still tax resident in the UK and paid from the UK, then income tax will still be due back in the UK. And that creates an issue of double taxation. And often overseas authorities, and let's take France for example, can deviate in how strict they are when it comes to how that income tax is administered, whether it's through payroll or not. And if we think about the French rules, so the French authorities will say, well, if a non-French resident company has an employee enlisted and working physically in France who is taxable in France, we have an expectation that the employer, the overseas employer, will enlist an agent to administer payroll in our country. Now that's awfully expensive to administer payroll and to maintain 2 forms of payroll on behalf of one individual who has just gone back to another country for their own personal reasons. And it's a pitfall that I've unfortunately seen with employers over the past, particularly over the past 12 months. And as they've introduced a hybrid working policy in recent months, that they haven't realised that this is going to have an impact when it comes to the cross-border working. Now that the other issue is that if you've got somebody who's paid from the UK who has tax withheld in the UK and then is physically working overseas, and then as a result of what I've just said has tax withheld overseas, they're going to have a double taxation problem. on a monthly basis. And as a result, how do you alleviate that? Well, you do that either through a mechanism in the payroll, which is extremely awkward and expensive, or they complete a UK and an overseas tax return at the end of the year. But again, very expensive and quite administratively heavy issues to resolve. The other aspect is social security, and social security is different to income tax. We call social security national insurance in the UK. And just so you know, national insurance for the is about to increase to 15.05% from 13.8% from 6th of April next year because of the recent budget changes. But national insurance in the UK is not treated, and overseas is not treated in the same way as income tax, which is a portion based on days, because you only pay social security in one country at any one time. But the really important thing to realise about social security is that there's two sides to it. There's employer and employee. And quite often the employer liability will often follow where the employee liability is established. And so when we look at the UK rates of national insurance, we look at, say, we look at 12% and 2% for, depending on the earning level, for an employee rate. And then we look at 13.8% for employer, again, going up to, all of these are increasing by 1.25% from the new tax year. But that sounds, that sounds quite expensive to a few. It's essentially an extra form of tax. But if we go back to that example of somebody in France, how social security is established is through ordinarily residence from a UK perspective. It's not like income tax for tax residency. But if the employee, by their presence overseas, is drawing an employer into overseas social security, that has a huge cost, because the UK, compared to a lot of EEA countries, for example, is actually quite low in terms of that employer social security. And if you were going to jump into French social security, the top slice of that is 45%. And if you compare 45% to even our increasing rate of 15.05%, that's a huge difference for an employer, just because you've allowed an employee to operate flexibly. That's a huge chunk of their salary that you're having to give to the overseas authorities. And so how you manage social security, to the point, is very important. And you should understand, before allowing anyone to operate overseas, particularly for a prolonged period or a regular period, is you should understand how social security will be managed. And there's strong potential to say that you can keep somebody who's working overseas and subject to overseas income tax. You can keep them in UK social security if you go about the advice in the right way and obtain certificates correctly. But it's another pitfall that unfortunately employers just aren't aware of when it comes to this issue. The other issue to be aware of are the kind of broader taxes, corporate and indirect taxes. And I wonder how many people on today's audience have heard of the concept of permanent establishment. But permanent establishment is a concept that's used in the world of corporate tax. And what it essentially means is that if you've got somebody who is working on your behalf overseas, they could have an income tax issue, they could have a social security issue. What about corporate tax impact? What the authorities will say is, do you have somebody who is potentially acting as an agent or an extension of your UK business overseas? And that is really, really important to consider, because if it is established that there is an agent or a dependent agent or fixed place of business established overseas, the authorities will say, right, then we want corporate tax off you because you are operating in our country. And even though you're just having an individual here, they could say that you are still having a corporate presence by their presence in country. And what that means is corporate tax compliance might have to be maintained. It might mean that overseas corporate tax is actually due on UK profits that are attributed to that person's presence there. And even though you might be able to, again, obtain credits, because corporate tax, like individual tax, allows credits and has a double taxation network, really important to get that right, because you really don't want to be burdened by that. You don't want to be a UK only organisation, allow your people to work overseas and then be drawn into tax compliance overseas and difference in tax rates overseas as well. So again, just another consideration. And if a permanent establishment is established overseas or fixed place of business, that could obviously have an impact on you registering overseas, paying VAT and other forms of taxes, as well as corporate tax overseas. And then the other area I'm just going to talk about is the area that a lot of employers seem to miss when it comes to these kind of hybrid working arrangements and temporary concessions abroad, in that you do have a duty of care to make sure that if something goes wrong, your employers are managed correctly. And so let's say that you provide, as part of a standard benefits package, private medical insurance. Does that extend overseas? What about allowances for differences in cost of living, for example, and other forms of benefits? And Marjorie will talk about the employment law aspects quite extensively after this, but there is another element of how do you manage the softer aspects away from tax and social security that might not be so obvious. I remember I was working with a client about 3 months ago who was really keen to implement a flexible working policy. We took them through all the things I've talked about so far, and then it got down to the issue of IT equipment. And this client in particular had very, very, very client sensitive information. And then the question arose of, well, what if they lose their laptop? What's our contingency plan for somebody being overseas? How do we discharge that data? How do we retain that data? How do we stop it from getting in the wrong hands when it's outside of our country? And they actually denied a working request because of that issue being so sensitive. So there's an awful lot of stakeholders that come into flexible working that aren't just involved in tax or the commercials. It's actually HR. It's also consulting with, applying what if something goes wrong. And these are the easy assumptions to make, which I've just sort of talked you through. So if I go back to the income tax point, very easy to assume that the income tax double tax treaty exemption will apply, but there are a lot of other factors that need to be considered, and really you should always be taking advice whenever you put somebody abroad. I put something up there about the economic employer principle. What that basically means is the 183-day threshold will come down very quickly to 60 days only per year if somebody is deemed to be economically employed overseas due to their seniority and the role that they play in the organisation. So important to understand that people's roles and the effect that they have commercially and economically on the UK business does come into effect. Social security, I said, it's really unlucky actually if you haven't planned for that effectively and been unaware how you should plan for that effectively. But a lot of countries will, the social security rules are governed on business postings. You are able to remain in the UK system if you are posted overseas for secondment. But I've seen quite a few authorities deny the fact that the definition of hybrid working does not match that of a business secondment. So social security could be due from day one if it's not the area of coverage that is defined in terms of what those local rules are. I've mentioned about permanent establishment risk being negligible, and importantly, whilst you might feel confident that there is no risk, how have you documented that? Have you taken any advice? What if the authorities ask questions, and what if the role changes? I've mentioned about the fact that it's not all about tax in terms of benefits and expenses, and also that a lot of employers will say, well, look, if you want to go and work overseas, by all means, but if you get drawn into income tax overseas, it's not our issue. In fact, I'm sorry to say that it can be. Certainly, if an overseas tax authority turns around to you and says, your employee is creating an income tax presence here, we want you as the employer, even though you aren't in our country, to administer that. And that is not cheap, and it can be, as I say, quite a burden. And so let's think about some of the solutions that you can put in place. Well, what we would say is that depending on how widespread and fast your hybrid working requests come in, whether it's in the UK or overseas, have a policy. It's really important to be upfront with employees on what they can and can't do. But equally, when it comes to international work, you can find a compromise to manage a certain number of days abroad that's low risk, so that no income tax, no social security, no payroll withholding, no registration, no permanent establishment applies. But what we would say is, we understand that it's not feasible to take advice every single time. So having a policy and taking some advice up front can actually remove about 80% in our experience of all the flexible working request pieces of advice that you would need. So it is worth having that investment, especially as this is the future of work. This is now much more beyond the kind of pandemic period, however long that would last. This is for the next sort of 10 years plus. So taking some advice up front can really help you manage your costs and how your parameters early on. Stakeholder buy-in, as I've said, it's not just about tax. You've got to think about legal, HR, obviously finance, but really there's a lot of people in the business who should be consulted with on flexible working, how it should manage. You don't want to cause any tension between departments by not speaking to HR about how flexible working, how private medical could be managed overseas, whether you need a policy extension or whether you need to say to employees, you need to prove to us that you have taken out travel insurance. And overall, it's really about getting this balance right and knowing when to take advice. As I said, I would recommend that every organisation who implements hybrid working, especially overseas, has a policy. But that policy is not going to solve everything, but it's going to reduce, it's a good investment because it's going to reduce the amount of times you need to take advice. And so if anyone has any questions on this area in particular, or you've got any cases that you'd like to run past me, or you are interested in formulating a policy, we can help. And with that in mind, there's also huge other aspects, another side to this, which is employment law. And Marjorie, if you wouldn't mind taking it from here, that would be fantastic.
Yeah, sure. I'll just share my screen and I can do the slides as we go along. Okay.
Actually can't see your screen. Seamless tech today, everyone.
Let me try again.
Got some
Can you see that?
mountains and we've got the slides.
Perfect. Thank you. So my name is Marguerite Perrin and I'm a solicitor at EBL Miller Rosenfalk. I specialize in employment law. Obviously tax tends to be at the forefront of everyone's minds when looking at hybrid working and working from abroad. But I'm just going to talk you through some of the key considerations on the employment law side that employees need to look at. So this kind of echoes what David was just saying. Just to go through kind of the contractual documentation that you might want to have in place, or non-contractual actually. So in terms of hybrid working policy, this is really the kind of key thing that we see employers are working on at the moment. And hybrid working policy is really for companies who want to embrace hybrid working to set out how they see it working day to day. So employers looking to implement hybrid policy will need to have a think about, how many days they expect employees to return to the office, if they are fixed days, or if it's something to be agreed week to week with someone's line manager. They might need to think about if they want to have team days in the office. So a specific team or department needs to be in the office, say on a Wednesday, because that's when their team meeting is. And if I've also put core working hours there. So say you are asking employees to be in the office 3 days a week, you can say, well, our core working hours are 10 a.m. to 4 p.m. That's when you're expected to be available for meetings, client meetings, etc. But outside of those hours, you can kind of make up your remaining working hours as you wish, as however works for you. And I think what's key to remember when you're implementing these hybrid working policies is, even though you may have had arrangements in the past 18 months, that was a very different situation because there were lockdowns. And now you need to think about what your staff want, and it might be actually a good idea to consult with your staff when implementing these, to make sure that everyone is kind of clear on what they want and what the future of working together in the office is going to look like. You might also consider actually having a trial period and saying this is going to be the hybrid working policy. We're going to give it a go for 3-6 months, and then do a review, see how it's working out. Because it kind of is a process of trial and error, because there's a lot of things that you might not have thought about which might come up as you actually try and implement this policy. I've also put flexible working policy. That is actually something different. You may have heard there's been a lot of hype around a new right to flexible working recently. It's actually not really a new right. There's always been a right to request flexible working, but it's now a day one right, which means that you don't have to wait and have 6 months of service with an employer before you request flexible working. And it's also key to remember that it's a right to request flexible working, but it's not a right to be granted flexible working. And the idea is that you can ask to change your working pattern. So whether that is to be solely based from home or to go part-time, to have different hours. And the employer has to, there's certain timelines that the employer has to respect to get back to you on your request, but they can also only refuse on one of 8 grounds, which mostly, well, they can be, you know, it's costing too much, or is going to have an impact on your colleagues or on service delivery, things like that. So that, I mean, that is also something to keep in mind, just because there is bound to be a lot more flexible working requests, but that is different to hybrid working policy, which is more a global policy applying to all staff. Put it in writing. So obviously, once you've agreed any kind of change to the working arrangement, then you need to think about whether you need to change the employment contract or not. If it's a temporary arrangement, you might just want to do a letter setting out what the arrangements are, if there's a trial period, if there's a kind of a review. And if there's a kind of more permanent change to the place of work, then you would need to potentially change the employment contract. The place of work is actually one of the pieces of information that you need to provide to employees in writing. So you need to think about doing that. I've also, David's kind of touched upon this, but how does hybrid working, remote working impact on benefits? Are you going to be paying for the costs of working from home, kind of utilities, you know, broadband, heating is obviously going to be a big cost for all of us this winter, it sounds like. So you need to come to an arrangement with your employees about that. Company car, if it's someone that used to go to travel to meet clients but is no longer doing that, are you still going to provide a company car? Private medical insurance and company car are also relevant if the employee is going to be working from abroad, which I'll come on to in just a moment. And really the key point with having these policies in place is that you might have within your workforce some roles that can be undertaken from remotely and some which can't. And it might be more obvious if it's operational roles and office roles, but even within office roles, you might have some administrative roles that you just can't do as well remotely. And so you need to make sure that these kind of everything is set out in a policy so that you don't have employees kind of saying, oh, you know, they got their flexible working request or they're allowed to work from home, but I'm not. And you don't want those kind of that kind of discord, and you don't want a potential discrimination claim arising from the back of that. So it's important to kind of have these policies in place so everything is consistent. So now we're looking at also at working from abroad, so working from another jurisdiction. So which laws apply? So just because you might be a British citizen and you have a employment contract with a British company, that doesn't mean that the law is the contract is subject to English law. Usually there is a choice of law clause in the contract that will say, you know, this contract is subject to the laws of England and Wales. But if you are based in another country, you will also, well, you may also be, you may benefit from what's called mandatory rules. And mandatory rules, they will apply from the jurisdiction where you're working from. So we're sticking to France because that's our example for today. If you were working in France, you might be working with UK clients, you might be only speaking to people in the UK, but the mandatory rules that could apply to you include the minimum wage, rules around working time, rights on termination, and those would all be French law rules. So essentially, as an employee, you would have the best of both worlds because you would have everything that's in your employment contract and anything that anything in French law that would offer more protection. So it is something that employers need to think about because they might not realize that they're falling foul of some French employment law rules.
Can I just, sorry to jump in, so I just can't hold myself back and ask a question.
Go ahead.
But so if you had, for example, a company policy where you're like, look, we're going to support you to work from wherever you want in the world, and like, of course, like there are some things that David's brought up, but we'll deal with it. Don't worry, we've got a really compliant and really happy to help finance team. Does that mean that your employee, let's say someone's in a someone knows that, I don't know, not doing great at their job, if they move to a jurisdiction like Germany or France or something like that have much more protected employment rights, they could go and then immediately benefit from the protections that you would get working in those jurisdictions?
So it wouldn't be all, and it's all, as always, it's a case-by-case basis, but it wouldn't be all the rules. It's only mandatory rules. And so what essentially that means, the rules to do with public interest and the rules that that country deems are kind of, you know, the basics of employment law, which is why it's really the kind of minimum things like working time and the minimum wage. You know, most of the time minimum wage might not be such an issue because you know, you probably have someone that has got quite a high salary, but if they're, you know, if working time might potentially be an issue if you're going to France. So yeah, it's certainly something to be aware of. And obviously this only tends to come up where there's some kind of litigious background with the employee, and that doesn't always happen, but you just want to be aware that there might be something there. Other considerations. So we've got health and safety, and that is something that employers have looked at when people have been working from home throughout the pandemic. But if they're kind of going and saying, you know, I'm now going to work from my holiday home in Spain, how can you make sure really that they have any of the equipment there? They might be working from a sun lounger, which sounds like it's might be terrible for your back. So if it's a temporary arrangement, that, you know, that probably is going to be okay. But if it's more long term, then you're kind of going to have to look at getting equipment, that kind of thing, over to them. Regulatory aspect, this isn't applicable to everyone, obviously, but if the employee is regulated by the FCA, you know, in the finance sector, or it might be the SRA if they're a solicitor, is there an obligation to declare to the regulator that some of the work is going to be undertaken from abroad, and it might be that some certain types of work can't be done from abroad. You've got data protection on there, and I think David kind of touched upon this. So you need to think about the confidentiality aspects, obviously, but also the data protection aspects. If your employee is going to be in a jurisdiction that is outside the EEA, then you're more likely than not going to be transferring personal data outside the EEA. So you need to make sure that you've got something that there to make sure you're compliant with data protection laws. You've got immigration. That's obviously a big one, you know, for UK citizens. Just because you're working for a UK company and might be speaking mainly to people in the UK, it's likely that you'll still need a visa with a right to work wherever you're going to be based. I mean, some countries have made the most of that. I don't know if you saw that Barbados has advertised a visa, the working visa, for a year for £1,500, which sounds very tempting. I've got kind of a catch-all administrative requirements, but I was actually thinking of something in particular, just still sticking to the France example. If you're going to post workers in France, you actually need, before they head out, you need to do a declaration of posting to the Labour Inspectorate. And yeah, it's called a Déclaration préalable d'embauche, and a lot of foreign employees don't know about it, but they do get caught out, and it does happen. They do check. So that's it. Really, I've kind of given you a checklist of things to think about. What I think the key thing to remember really is that you know, some companies have put in place a blanket ban on remote working. I don't think that's particularly realistic, because it's such a huge topic in recruitment and staff retention and that kind of thing. And so a blanket ban on working from abroad, you also need to think about whether that's discriminatory to your employees who are not UK citizens, because UK citizens will be able to work from you know, their parents' house at Christmas, but you know, if you have a German employee, then they wouldn't be able to do the same thing with their family. So you would need to really think about the justifications for any kind of ban. you might take the view that some certain arrangements that are temporary with are low risk, and if you have the policies in place, and as David said, if you've taken the advice, legal tax advice on the policies that you've put in place, and you take the view that it's low risk, then that might be something that works for you. We know that obviously employers don't necessarily have the resources to examine every flexible working request on a case-by-case basis, but there's some things that you can do to kind of keep the risks down. But it's certainly not something that you can get away with just ignoring. It's going to come back, and you kind of need to engage with the topic now at the outset, really. And that's it from me. So I will hand back to Felix.
Awesome, thank you so much. That was really interesting, and I think you're bang on in that. What we're seeing in the talent market, and we operate across a number of different industries, but it doesn't matter which industry you're in. This is such a live topic, and it's so important to prospective employees and existing employees that it's going to be one of the key factors in your business's workforce attrition or ability to hire top talent. So it's something that people really need to get out in front of. And by the way, this question is not geared at getting free legal and tax advice. I think, well, maybe it is. What the way that we've approached our geographical expansion or global expansion has been, we've identified the markets where we think we're going to be hiring a lot of people and growing, or where some of our team might go out, and we've done the sort of setting up working policies and all of the tax compliance and all the rest of it, for example, in the US, which is a whole another webinar for another time. But for the other markets, we have come across, I'm not sure if you guys have, I'm sure you will have done, but like sort of companies like Omnipresent that are sort of employer of records that can deal with the legal and tax litigations in the other countries that we employ, for example, South Africa. And essentially what they do is, for those that don't know, is they are the people that end up employing the person. They kind of contract them back to you, for want of a better term. Have you guys come across that, and do you think that they're as revolutionary as they're claiming to be? They certainly seem to be all over the place at the minute.
Yeah, I have. I mean, the PEO model is a great solution on one hand, because you want to employ somebody abroad, but you don't want to pay them in the UK because of the fact that creates payroll administration. You want them to be essentially still part of your organization, but you want someone else to take care of that overseas admin. So why not have a payroll agent overseas? I think there's two things that I've spotted with clients who have experienced PEO models. First off, it's quite expensive. I think in the PEO market, they know that this is a solution, and like any commodity, they realize that you take somebody's salary and then they will charge a markup, a percentage of that person's salary. So how feasible it is in terms of employer costs in the long run compared to setting up an entity and expanding, that's something to consider. But the other thing, a PEO model does not negate the tax risks. So as an example, you could still have a permanent establishment created abroad or fixed place of business overseas, even though somebody is in a PEO model. And as a result, I think that's a misconception. It's the fact that the PEO is a great solution admin wise, but it doesn't solve the tax risk.
I was worried you'd say that, David. How about from the legal side of things?
So we'll talk after this, Felix.
Yeah, of course. How about from the legal perspective, Margaret? Have you come across that?
Not so much, really. I would say that, yeah, if it sounds like a good solution. Obviously, you would still need to get kind of local legal advice. I don't know to what extent they offer kind of legal services and in the jurisdiction you're looking at, but if it's more HRE type, then they probably just have templates that they're downloading from the internet. So it is worth getting kind of local lawyers involved as well.
Very interesting, thanks. We have a legal definition question, which are, in these kinds of topics are very important. So what exactly, we've been talking about hybrid working, flexible working, all the rest of it, and I think specifically around flexible working. What's the sort of legal definition of that?
Of flexible working specifically?
Yeah.
So I would only use flexible working in the context that I've explained. So as in an employee makes a request for flexible working, and that is just means a change to their working arrangements. So it could be that you want to go from 5 days to 4 days a week, or you want to start earlier in the morning at 8 a.m. to and finish earlier so you can, I don't know, go pick up your children or something. And it's also, so it can be a change in working hours or working the location that you're working from. So it could be home working. It could potentially be someone asking to work from abroad, but obviously that's just a much more complicated request than the others.
Fantastic. The one of the concerns and challenges that we come across on the talent side of things when it comes to hybrid working, and sort of I think the sort of what we're seeing emerging as sort of paradigm of what you should be doing as an organization is to empower your employees and team to work in the way that suits them, from the place that suits them, in the way that's going to get the most productivity out of them at the end of the day. That's a sort of, without any of these like practical constraints that we're talking about today, that's what everyone wants to do. And I think one of the challenges from a talent and culture perspective is that you end up with these are the remote folks. Here are the London people. Here are the New York people. They go out for beers. Remote folks get left out. So there's a culture concern that people are looking at, a sort of us and them element. But Margaret, was I picking up that there might be a discrimination and employment law concern around allowing some people to work remote and others not?
Yeah, there could be. And I think you're spot on with the kind of divide between the people who might be permanently working from home and people who might either be hybrid working or based in the office. The concern really is that people who can't make it into the office might be people with childcare responsibilities, and people who are not based where your office is. Say your office is based in London, it might be someone based in Manchester or wherever. And so you're looking at really, it's really tricky because you want to ensure that as far as possible, there's no divide between the two. And if that includes, putting technology in your offices so that people can easily join a meeting remotely, even though it's an in-person meeting for everyone else. And I think that's probably one of the biggest problems is to ensure that you don't have this divide. But yes, if it's someone, for instance, if it's a mother with childcare responsibilities who can't join work from the office, and she's getting left out of maybe after work drinks and kind of opportunities to speak to clients and potential promotion opportunities, then yes, that's definitely an argument waiting to be made about maternity discrimination and sex discrimination. So it's something to be worried about.
I asked the follow-on question about companies that are setting up a remote pay docking system. So if you're working remote, you get a certain proportion of your salary knocked off. Is that a dangerous one to pick up?
That is very it's very dangerous to put in place, and it kind of obviously if what you're going to create is people who were there before the pandemic might be working totally remotely but still have London salaries, and then new recruits would just have a remote salary that's a lot lower. If you can objectively justify it, it might work, but then equally that I think we're going towards more transparency in terms of salary and pay, and so it might create discontent between the employees if they find out what others are paid. So it's something to think about, but it's dangerous waters.
Spidey senses are tingling.
Yeah.
David, we've had a fantastic question in that I think is really well suited to you. And anonymous attendee has asked, could you mitigate your exposure by limiting working from abroad in your hybrid working policy to say 4 months per year? Would that work?
Yeah, it's a great question. And I think initially you could look at it and say, well, if it's 183 days for income tax purposes, well, let's go a couple of months beneath that, and then are we good? For social security purposes, or from a national insurance perspective, if somebody comes into the UK and works here for 6 continuous weeks, there is potential to say that they will have to be liable then to UK national insurance. And the rules do vary country to country on what they define as the equivalent of that. And what that does is that brings that 183 threshold quite rapidly down to a period of no more than 6 weeks to be really comfortable. And it all depends on your risk appetite, but that's to be really comfortable on the Social Security side. On the income tax side, that could work, but if you recall me mentioning about one of the pitfalls is that 183 days can come down to 60 days because of the economic employer principle being applied, then again, 4 months would go beyond that quite substantially. So I would say, so being frank, when we work with organisations who really want to remain competitive on this, allow flexible working overseas, but you are putting a sensible limit on it, we would say no more than, say, 20 or 30 working days abroad within each rolling 12-month period to be really secure. If you go beyond that, you could step into a country that is a lot more stricter on the Social Security side without knowing, and that's when you could cause problems. So if you're going to have a generic policy, we'd bring it down. Of course, if you wanted to have a country-specific policy whereby you have different limits per country, which some large organisations do want because authorities are different, then you can potentially have 4. But as I would say, for a generic policy, that needs to come right down for the reasons I've explained.
Understood. Well, guys, it's 3 minutes to 12, which is when 12 is when the webinar ends. All that's left, the only time that's left is for me to mumble around a bit, but also to say thank you very much for joining us and for your very interesting professional opinions on the topic. I really enjoyed hearing all about it. And just to head off the questions, we will be sending around a recording. We will be sending around both David and Marguerite's contact information, and we may well be sending around a sort of checklist or something like that for all the things that you need to bear in mind from today's webinar. So thank you both so much, and I hope everyone has a fantastic afternoon.
Thank you.
Thanks, everyone.